A client sits in your office. They've been married for exactly 6 months. The relationship has collapsed, and they want an immediate divorce. They expect to sign a document and walk away. As a family lawyer, your first task is explaining that the legal system moves on its own rigid schedule, regardless of their emotional urgency. Under current law, there is only one ground to end a marriage or civil partnership, demonstrating that the union has broken down irretrievably. But before the court will even entertain that ground, it enforces a strict jurisdictional waiting period. Looking at Section 4C of the practice module here, we see the absolute statutory gatekeeper, a strict bar to applying for divorce or dissolution within 1 year of marriage or civil partnership. Advising clients effectively in these situations requires you to navigate this 1-year bar, often by using judicial separation to secure their finances and safety now, while preparing the paperwork for the post-year 1 dissolution. Your role is taking their immediate crisis and mapping it onto a structured, statutory timeline for relief. That 1-year bar is a mandatory jurisdictional requirement. The family court literally cannot process a divorce or dissolution application filed on day 364. This restriction is codified in 2 parallel statutes, covering both types of legal unions. Here in the module, we see the exact citations you need. Section 3 of the Matrimonial Causes Act 1973 for marriages, and Section 41 of the Civil Partnership Act 2004 for civil partnerships. However, the law distinguishes between filing an application and experiencing the breakdown. While you are barred from applying during that first year, the underlying facts of the breakdown are not erased. Once that 12-month clock expires, the applicant is fully entitled to rely on any events that occurred during the first year of the union to support their statement. As this diagram illustrates, Year 1 acts as a locked box for court filings, but any evidence gathered inside that box flows directly into the open filing slot in Year 2. For the practitioner, Year 1 is a period of active data preservation, not legal stasis. When a client cannot wait for that 12-month mark to pass, you have an alternative remedy: judicial separation, or simply separation for civil partners. The core advantage of this procedure is immediate access, bypassing the strict anniversary requirement. As the syllabus outlines in Section 4E, judicial separation is available in the first year of a marriage or civil partnership. Legally, this order terminates the obligation of the spouses or partners to live together, but it leaves the union itself legally intact. Because the marriage or civil partnership is not fully dissolved, the parties are constrained from remarrying or forming new civil partnerships. Despite that limitation, the procedure offers tremendous practical utility when a client requires immediate court intervention for domestic abuse or physical safety. It also allows the court to make immediate, binding orders regarding child arrangements and the occupation of property. The financial scope is broad, allowing for maintenance and lump sum orders to stabilize the client's position before the divorce is possible. There is, however, a notable exception. Pension-sharing orders are generally unavailable under judicial separation. Looking at this decision tree, identifying the need for urgent financial or protective orders in the first year routes the case toward judicial separation. It provides immediate legal structure and protection while the client waits to reach statutory eligibility for a full dissolution. Once the 1-year anniversary has passed, the client becomes eligible for the formal dissolution process. The Divorce, Dissolution, and Separation Act 2020 modernized this procedure. Checking Section 4B of our source text, we see the shift to a no-fault system. Applications can now be made jointly, and there is no need to prove conduct facts like adultery or behavior. Irretrievable breakdown is now established by a simple, unchallengeable statement provided by the applicant or applicants. The process begins digitally with the issue of the application through the online portal. Once issued, the system imposes a mandatory reflection period. Section 4D details a minimum wait period of 20 weeks before you can apply for the conditional order. This conditional order is the preliminary confirmation the applicant is legally entitled to divorce. After that order, there is a second waiting period. Moving down the document, we see the final step, a minimum 6-week wait before applying for the final order. The modern system trades the necessity of assigning blame for mandatory delays, using statutory waiting periods to ensure the termination of the union is approached with deliberation. Successfully managing a relationship breakdown requires balancing the jurisdictional restrictions of the first year, the immediate bypass of judicial separation, and the no-fault pipeline of the 2020 Act. Your primary advisory duty is determining exactly where the client sits on this statutory timeline before recommending a path forward. This timeline maps the client's journey. Year 1 is defined by the availability of judicial separation and protective orders, transitioning smoothly into Year 2, which is governed by the procedural milestones of the 2020 Act. While the recent legislation simplified the terminology and removed fault, the necessity for tactical timing remains entirely in your hands. Alongside these procedural mechanics, you carry an ethical duty to advise the client on mediation requirements, like the MIAM, and funding options from the very first meeting. You also have to manage their expectations, contrasting the absolute finality of the final order with the temporary, bridging nature of early separation remedies. Your high-level objective is providing precise, actionable counsel, regardless of how recently the client entered their union. Family practice requires strict adherence to professional standards and complete statutory accuracy at every step. Competence in this field depends on applying the correct statutory framework at the precise moment a client is eligible for relief. By mastering the statutory timelines and alternative remedies, you give clients navigating the complexities of relationship breakdown exactly what they need: clarity and structure.